Welcome to Module 5, and this is about the U.S. Supreme Court and its power. I'm Dr. Ron Campbell, welcoming you to this law module. Now, you know that the U.S. Supreme Court is powerful, and you know that the U.S. Supreme Court can declare unconstitutional any law passed by Congress. But where does this power come from? Does it come from the U.S. Constitution? Now, this is my pocket copy of the Constitution I carry around with me, and I'm looking at the various sections which talks about the powers of the presidency and the powers of Congress and the powers of the U.S. Supreme Court. And is the power of the U.S. Supreme Court in this document? It was invented by one man. And you're going to learn about it just right now. But first, we're going to take a look at the most cantankerous election in American history, where, for the very first time, one political party gives up and a second political party takes control of the White House.
The United States Supreme Court is a human institution, shaped and forged by the justices themselves.
John Marshall really changed the way judges do business.
He thought that a unanimous court spoke with a stronger voice.
This is the story of one nation under law, the Supreme Court.
The issues change. Before the Civil War, the issues were slavery or state sovereignty, federalism. In the last part of the 20th century, the issues are culture war issues. But again, you have this Constitution that doesn't yield real clear answers.
Justices are trying to apply the Constitution in light of all of American history and in light of the peculiar circumstances that we as a nation find ourselves in today. And it's hardly surprising that under all these circumstances, different people will have different views on what the Constitution means. It would be an incredibly weird country if everyone agreed on everything.
The court will never be that far out of tune with the prevailing attitudes and prejudices of its time. Nevertheless, when the court speaks, it's supposed to speak for what the country stands for, our basic values, our highest aspirations. And so we put a lot of faith in the court, and a lot of us want the court not to let us down.
The Supreme Court did not always hold such sway in the life of the nation. In the early years of the Republic, justices were unsure how far their power extended and shy to exert it. One man changed all that.
I think nobody, until Marshall comes along, I think that anybody really have a coherent vision of how powerful this institution could become.
The base that Marshall built in law and in tradition transcends his life and animates the rest of American history. Part of the genius of John Marshall is that in a very real sense, he invented the Supreme Court.
The United States Supreme Court was written into being at the Constitutional Convention in 1787. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The framers knew they wanted an independent judiciary, free from the pressures of politics, but little else was determined. The Supreme Court's inaugural session did not portend a powerful future.
For the first year, nothing comes to the court. They have a 2-hour session in 79. They have no cases, and they all go home. They're given a second floor room in some building in New York. I mean, nobody sees this as having the majesty of the executive branch or the legislative branch.
The Supreme Court was a court of law, but it wasn't established as a constitutional court. So its early decisions tended to be just everyday, run-of-the-mill legal disputes, not great constitutional questions.
Congress originally set the number of seats on the court at 6, lifetime appointments all. But it was no mean task keeping the bench filled.
Membership on the Supreme Court was in a great deal of flux. People didn't stay on the court very long. The first Chief Justice, John Jay, left to be governor of New York.
The president wanted to appoint John Jay to the court again, and he refused. He declined. He said, the Supreme Court is not an institution with a lot of energy. It's just not a great job. I'm going to take a pass on that.
It had so little prestige as an institution at that point that it was really an afterthought. The court was off on the sideline and played almost no role.
It was the tumble of partisan politics, not the imperatives of the Constitution, not the majesty of the law, that drew the Supreme Court into the momentous battles of the early Republic, that vaulted a 45-year-old Virginia politician named John Marshall to the bench, and that started the court toward its destiny as a dynamic and co-equal branch of the federal government. By the time George Washington retired from the presidency in 1797, the country had split into factions, the first political parties. New President John Adams and Federalists such as Alexander Hamilton and John Marshall on one side, Vice President Thomas Jefferson and his new party on the other. Their differences seemed fundamental and had widened as each side watched the democratically fueled French Revolution devolve into mass murder of the aristocracy.
For Marshall, the French Revolution was anarchy, attacking order, attacking property. Jefferson's response was, it's a good thing to spill a little blood every once in a while. You need to do that. A little revolution is a good thing. It shakes people up.
Federalists didn't intend to let unchecked democracy, the mad passions of the people, threaten their fragile new republic. To hold the mob in check, they championed a stout national government, led by the educated and landed elite.
Jefferson believed that the Federalists represented a new monarchy, not much different from that which we declared our independence from in Great Britain.
When Hamilton said, I think we need a standing army, the Jeffersonians immediately assumed the worst. What are you going to use this army for? To oppress us, to draw all power to yourself.
The Federalists had, in fact, consolidated their power in government. They controlled the executive branch and the Congress, and had appointed each and every federal judge. From his Virginia plantation, Vice President Jefferson began running an all-out insurgency against the ruling party. The Second Revolution, he called it. He meant to ride people power to the presidency. As Jefferson stirred dissent, visions of the French Revolution danced in Federalist heads.
Jefferson was known for his Francophile leanings, and there was real concern that there would be bloodshed in Washington if Jefferson came in, and heads would roll, almost literally.
You could look back at that and say it was ridiculous to think that Jefferson was going to lead a revolution that led to bloodshed, but at the moment things were pretty much up for grabs.
The politics of the day were partisan and ugly, and there was no precedent or tradition that demanded the judicial branch steer clear. Federalists appointed lower court judges, enforced the plainly unconstitutional Sedition Act, tossing Jeffersonian pamphleteers and politicians in jail for merely criticizing President Adams. And as the election of 1800 neared, many of those judges campaigned openly against Thomas Jefferson. Then the Jeffersonians won, big. Jefferson took the White House from Adams, and his party men swept into majorities in the House and the Senate. But there was no way to sweep the nation's courts of Federalist partisans Jefferson despised. Judges were appointed for life. The Federalists, wrote Jefferson, have retired into the judiciary as a stronghold. And John Adams meant to shore up the Federalist breastworks. In the aftermath of the election, the angry lame duck president installed his close friend and then Secretary of State, John Marshall, as the new Chief Justice of the United States. Marshall's appointment blocked Jefferson from naming his own chief, and it sent a clear signal to the incoming president. John Marshall would be watching him.
Jefferson was building a country, and he had a very extended vision of where things were going to go. And I think he became pretty hardcore about people who got in the way. And he saw Marshall as someone who was getting in the way.
The swearing in of Thomas Jefferson has got to be one of the great ironic moments in American history, because you have Chief Justice Marshall swearing in his second cousin, Thomas Jefferson, and both men pretty much by that time hated one another. They feel that the policies represented by the other person was detrimental to American civilization. It was as fundamental as that. So you have Marshall holding the Bible, Jefferson swearing to uphold the Constitution, which Marshall was absolutely sure he was going to destroy.
The first fight between Jefferson and Marshall was a fight picked by John Adams on his way out of town. That quarrel would spill into the United States Supreme Court. On paper, Marbury versus Madison involved a small technical question of administrative housekeeping. But in the political swirl of 1801, this seemingly straightforward legal case would determine the future of the court and test the cunning and ability of the new 45-year-old Chief Justice. Marbury versus Madison began with another breathtaking act of partisanship by the outgoing President John Adams. Just weeks before Jefferson's inauguration, the lame duck Federalist Congress had passed legislation swelling the federal courts, and Adams stuffed them full of anti-Jeffersonians.
At the very end, literally the last day of Adams' presidency, he was busy signing commissions for these federal judgeships, including these justices of the peace. And the hour got very late, and he had to get the commissions signed, and then they were sent over to the Secretary of State, who happened to be John Marshall. And Marshall had to put the seal of the United States on it, and then they were to be delivered to these designated justices of the peace.
John Marshall knows he can't deliver them all. He gives about half of them to his brother James to deliver. James doesn't get around to delivering them before time runs out. The key lesson of Marbury versus Madison is don't give important documents to your brother.
When Thomas Jefferson arrived at the executive offices, 17 commissions sat signed, sealed, and undelivered. He directed his new Secretary of State, James Madison, to leave them lay. 10 months later, a would-be Justice of the Peace named William Marbury showed up at the Supreme Court, asking Marshall and his brethren to compel Madison to deliver his commission. John Marshall ordered Madison to show just cause for withholding Marbury's commission. Madison didn't feel obliged to bow to the court. He simply didn't answer. But when word of Marshall's demand spread through the Capitol, the Jeffersonians in Congress were not so passive.
Congress passes a law that basically closes down the Supreme Court for a full term. They just cancel the term by statute. And there's nothing in the Constitution that says they can't do that specifically. On the other hand, it's a pretty aggressive attack on the court.
There was the real feeling on the part of the justices that their days were numbered. And Marshall himself, I think, felt under considerable threat of impeachment.
The court was in its congressionally enforced recess for 14 months, while the Jeffersonians threatened to dismantle the entire Adams-built judiciary. Marshall stayed home in Richmond, Virginia, with his wife Polly and their 6 children, puzzling out his next move in Marbury versus Madison. He didn't have a lot of good options.
If he backed down, if he was seen to back down, the court would lose all prestige. It would take generations for the court to recover from that act of cowardice. If, on the other hand, Marshall bravely gave an order to President Jefferson, command the Secretary of State to convey the commission, the administration would disobey, pay no attention to the court order. And in that case, the Supreme Court of the United States would be a laughing stock.
Marshall doesn't want to have that situation because then the court looks powerless, and it sets a precedent that the court doesn't have to be obeyed. Everything people do in this time is setting a precedent. They're very aware that it's the first time for everything.
When Congress permitted the Supreme Court to reconvene in February of 1803, the first case on the docket was Marbury versus Madison. The court was meeting in the lobby of a Washington hotel, and partisans on both sides milled the halls, anxiously awaiting the court's judgment. When Marshall announced the decision, it confounded almost everyone.
He says, well, Mr. Marbury, you have been wronged. The Jefferson administration has completely illegally withheld your commission, and that's a horrible, terrible thing, and we deeply feel your pain. However, just when Marbury thought he had won, see, you're in the wrong place to get any help, and this is not the proper tribunal for us to help you, so good luck with that. Bye.
Most Jeffersonians thought of it as a victory for the Jeffersonian administration because, in fact, they had won. This guy wanted to have a court order Madison to do something, and Marshall said no.
It was trumpeted as something of a victory for Jefferson. It made it hard for Jefferson, who I think realized very quickly that it wasn't such a big victory.
It took some doing to untangle Marshall's opinion. The Chief Justice had taken Jefferson to task for trampling Marbury's rights. He'd also asserted the power to force the president to comply with the court order. But he'd run away from the real fight, explaining that he was powerless to issue such an order in Marbury, because in this particular case, the Supreme Court did not have jurisdiction.
In order to hold that there's no jurisdiction, he has to strike down an act of Congress. And so, as part of his holding that there is no jurisdiction, his way of backing out, in a sense, he reaches out and takes the power of judicial review to boot.
The court's power of judicial review, the ability to strike down any law repugnant to the Constitution, was not written into the Constitution itself. Jefferson believed the court had little standing to be the final word on the constitutionality of laws. In fact, he thought it dangerous to give so much power to men who were appointed for life and did not answer to voters. But in his Marbury opinion, in his own hand, John Marshall scrawled into the record the court's central power.
Judicial review is the capacity to say this law does not comport with the Constitution. It's not really law. It's void. The trick is that nothing in the Constitution says that the Supreme Court has this power. No language in Article 3, which creates the courts. No language in any part of the Constitution says the court has the power to strike legislation. We know the President can veto legislation because Article 1, Section 7 says he can. We know the Supreme Court can strike down legislation as unconstitutional because John Marshall said it could.
It was emphatically, as he said in Marbury versus Madison, emphatically the province and duty of the courts to say what the law is, and the Constitution is law. In most governments, if not all at that time, the Constitution was regarded as a political document. Marshall's real significant and unique contribution was to view the Constitution as law. And once you accept that the Constitution is law, then the courts have a significant role, because courts tell you what the law means.
He's asserting the constitutional equality of the court in the constitutional scheme, that they were going to push back, that they had a role to play, a major role to play, the major role to play perhaps, in interpreting the meaning of the constitutional text.
Marshall holds down a decision that Jefferson despises. The court has the power of judicial review, but does so in a way that Jefferson can't evade it. I mean, the only way Jefferson can get around the decision in Marbury v. Madison is to give Marbury his commission. I don't care what Marshall says. Here is your commission. Well, Jefferson's not going to do that. That is classic Marshall.
So a pretty good day for John Marshall, right? He's avoided a political crisis, he's publicly scolded the president for behaving badly, and he's established the most important power that the court owns. There is no Brown versus Board of Education, there is no Roe versus Wade, there is no Bush v. Gore without a power of judicial review.